Now, concerns are raised over the alleged defendant in this case. Was he out on bond? Why is he out on bond? How does the bond work? Because we all live in polite society, right? Polite, maybe some air quotes around it. But unfortunately, we seem to be living by the bottom 10% of society.
We are the Armed Attorneys, and today we're going to be talking about the awful stabbing on the train of Iryna Zarutska and some questions about defense of third parties, and then also touching on the issue of bond. I know there was a big uproar about the fact that the man was out on bond at the time that this occurred. I think we want to start by kind of saying that we understand that we're a little late to this discussion, but I think we're going to take some different takes on how it plays out. But before we begin our discussion, show your support for the Second Amendment by hitting that like button.
All right, so this is a tragic case.
Absolutely.
Yeah, we've had a lot of trauma in the past couple of weeks. I don't think most people are designed to see, back to back, first Ms. Zarutska, then Charlie Kirk. This is not everyday stuff. We hope, right? I wish that were the case. But we've gotten a lot of questions about self-defense, defense of others, in particular to her case, and kind of the lingering bond issues, because I think there might be a little bit of a misunderstanding about, what a bond is, how it functions, how this guy was out. And I mean, there really are some things that we could do to probably shore this system up. So we're going to be talking about that.
Yeah. And, I think the big thing is, and a lot of the uproar is that no one else on that train did anything.
Yeah.
I mean, everyone sees this man stab this poor girl and no one jumps in.
Or fear becoming Daniel Penny in New York and getting charged with murder.
Right. Yeah, no, definitely. So, big question. Could someone have stepped in and used deadly force against this man to defend her? Would that have been justified?
And I think the short answer is yeah. Yes. And how do we get there? Well, if we look at defensive third-person laws across the United States, they look pretty similar. Essentially, you put yourself in the shoes of the person who is being threatened with unlawful deadly force in this case. And what level of force would she have been justified in using to defend herself? Well, deadly force. Third persons could come in and use deadly force in response to his unlawful use of deadly force to protect her. Again, this all has to be reasonable and immediately necessary. You're stuck in a confined space with this person. And I think a lot of, maybe to contrast it a little bit from the New York case with Daniel Penny, was this person still a continued threat such that it was immediately necessary and reasonable to use deadly force against them? And I would say, yeah.
I mean, yeah, definitely.
You're holding a knife within arm's reach of all these people. I think that's where you get the answer yes.
Yeah, and I mean, he's walking down that train. He's walking towards other people. I mean, I don't know how the people on that train knew that he wasn't about to stab them and they weren't about to become the next victim. So, I mean, I think there's an argument even to be made, had someone stepped in, that it was actually defensive of themselves as well. Because they don't know what he was going to do next. They don't know if he was going to keep on a spree. And, all those people kind of got lucky that he didn't.
Yeah. And I think a question, again, I think this is hypothetical, and I don't think there's any evidence to support this. But there are several people making the allegation that Ms. Zarutska made some type of racial remark that triggered the attack. Let's say true, just for argument's sake. What we see almost universally under every state's law is what?
That you cannot use force or deadly force to respond to remarks or words alone. What the law almost always says is that words alone are not enough to prompt you to use any sort of self-defense.
Yeah, not even talking deadly force. Force,
right.
And this is the sticks and stones may break my bones, but words will never hurt me kind of rule. That is it codified into law.
Right.
Words alone don't justify any level of force. And how that plays out, let's say he even raises that at his trial, because you raise something at trial, especially when it comes to self-defense, maybe you get a self-defense instruction. It specifically says you don't get self-defense under those circumstances. So one, is he going to get a self-defense instruction? I highly doubt it. If he did get a self-defense instruction, it would be limited to something along the lines of, hey, the defendant may not use any level of force if it was in response to verbal provocation alone. And so if a jury says, okay, yes, she provoked it, was it just verbal, then we cannot allow him or consider self-defense. So it doesn't really shake out. It's completely irrelevant.
Yeah, no, it definitely is. And this it's just something to think about. Now, next thing we always get is, what if someone says, "I'm going to kill you," as they're raising a knife? Well, okay, that's a different situation. Now
Yeah,
they have
that's
a deadly weapon.
yeah, that's not so when we talk about words alone, that's not words plus lunging towards you plus
Right.
reaching for their waistband plus coming at you with a so that's not a words alone. That's a word plus action. In I haven't been able to see there's I've seen her. I don't see any actions by
No,
her.
no,
So
she's sitting there minding her own business and gets brutally attacked out of nowhere.
now concerns are raised over the alleged defendant in this case. Was he out on bond? Why is he out on bond? How does the bond work? Because we all live in polite society, right? Polite, maybe some air quotes around it. But unfortunately, we seem to be living by the bottom 10% of society.
Yeah.
And I mean, that's exactly what the system is kind of designed for. And it does shock the conscience of a lot of self defenders, folks who've never been in trouble before, when they get kind of grouped in with all these people who are like we saw on this train. But, what's going on there?
Yeah, this is a conversation that I have with a lot of my clients. It's a very hard conversation to have because they'll say, well, why do I have all these bond conditions? Why is the judge saying that I can't do drugs or I can't drink or I can't go here, I can't do this? I was defending myself. I'm not a bad person. And while I 100% agree with them, unfortunately, the judge isn't making a decision on whether or not this was self-defense while they're setting your bond. Now, they definitely do take that into account. They definitely do hear the facts. You can argue it was self-defense. And a lot of times they probably will lower your bond if they hear it was self-defense. But a judge's concern is being blasted on the 6 o'clock news. They're elected officials. They want to make sure that their name stays good. So when a judge lets someone like this man out on bond,
It was a non-lawyer magistrate.
it was, yeah. And
That's
right.
exactly why they don't care.
Right, exactly. But it plays into all the other judges, and so they kind of get a little worried, and they say, "Oh, well, I don't want this to be my name that's blasted all over there." So now they're imposing bond conditions, just run of the mill. Everyone, you're charged with a felony. These are the bond conditions you get in my court, no matter what your specific situation is. So people like this getting out on bond and committing more crimes, affects people who are law-abiding citizens, are law-abiding gun owners, who get forced to do something to defend themselves and then unfortunately get arrested, and now they're out on bond with bond conditions that they shouldn't have. And typically in my cases, a lot of times the person doesn't actually know the alleged victim. So, there's always bond conditions saying you can't go within 200 feet of that person. Well, a lot of times my clients say, I don't know who this person is. I don't know where they live. I don't know where they work. I couldn't go find them if I wanted to.
Yeah.
So that's something to think about.
Well, and this is one of the things that grinds my gears, because our system, like I said, we're all kind of living by the lowest common denominator, whether it's in public school or if it's our, system of justice. Well, it's really well designed to handle folks who have high agency, who have things to lose. The system's designed to handle those folks really well. For kind of vagrants, folks who they don't have anything to lose, they don't, the system doesn't really know how to handle these things, and I don't know what the solution is. I've racked my brain over this for years, and the suspect in this case kind of falls into that latter category, because my understanding was he was currently on bond for something else, and guess what? It didn't work. Turns out that crazy murderers don't follow rules. I mean, this isn't a newsflash to anybody, but for folks who maybe they are self-defenders, yeah, they do find themselves in that uncomfortable position of being grouped in with a system that's trying to handle everybody equally, and it's equally terrible.
It is.
But fundamentally, I mean, what a bond is supposed to do is secure the person's attendance at court and trial, right? The general rule is you stay in jail until your trial. The big exception to that is you're released on bond, and this is a promise, usually it's some kind of collateral and a promise to appear in court. And the collateral and the conditions are supposed to be such that they secure your attendance. But, in these places where we see no bonds, people released on personal recognizance bond, doesn't really matter what they're doing. That combined with there's no consequence for them violating, plus they don't have anything to lose, so it doesn't matter anyway. We do need to find some solution for that.
Yeah, and I mean, here in Texas, the only time that a judge can no bond someone, meaning that they can not give that person a bond, is a capital murder charge or on a motion to revoke probation. So any other kind of charge, the judge has to give that person some sort of bond. Now, of course, they can give that person a very high bond that would prevent them from bonding out, but I mean, sometimes people come up with the funds. Sometimes, people's families get together and sell a home or something to where they can post the bond for that person. So the judges can only make a bond so high because it still can't be used as a tool of punishment. And then in most situations, they unfortunately have to give the person a bond a lot of times.
Yeah, and just thinking out loud, I mean, part of what would solve this problem if, it didn't take a year, 2 years, 3 years to get to
Right.
trial, if we could process folks, and this is to the benefit of self-defenders. If you have your justification claim, your self-defense incident, and that thing is concluded in 60 days, guess what? You're either a free man or, what? The jury found you unjustified, whatever the punishment may be, administered. Well, the same thing goes. We don't need this complicated bond structure if these cases were being administered in a more timely manner.
Yeah. I mean, I have a case pending right now that's going on 4 years. So, and we can't get it in front of a jury, unfortunately. So, that's the hard part.
Yeah, but even though not a fun topic, we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video. And don't forget to leave your questions and comments in the section down below. Until next time, we're the Armed Attorneys.